one Justice Department nominee who are ready for a vote. We also have 6 U.S. Attorney nominees listed for the first time. I understand there's a request to hold over 3 of those attorney nominees. So we will hold over Claire Connors, U.S. Attorney for the District of Hawaii, Zachary Cunha, I hope I pronounced that correctly, is that right? Oh, I'm sorry, thank you. Zachary Cunha to be U.S. Attorney for the District of Rhode Island, and Nicholas Karrast, is that right, Pat? Yes. Nicholas Karrast to be U.S. Attorney for the District of Vermont. We also have one new bill on the agenda that will be held over, S-2342, the Ending Forced Arbitration of Sexual Assault. This bill was introduced by Senators Gillibrand and Graham, and I'm co-sponsor. We also have 2 other bills on the agenda that have previously been held over. S-2428, the False Claims Amendments Act of 2021, and S-998, the Driving for Opportunity Act of 2021 as well. I'll address those bills after the nominations. Let me go through the nominations as quickly as I can. First on today's agenda is Judge Lucy Koh for the Ninth Circuit. Familiar to many of us, President Obama nominated her to the Ninth Circuit back in 2016. She received bipartisan support with then Chairman Grassley and Senators Hatch, Graham, and Flake supporting her nomination. She was an outstanding nominee in 2016 and still is. Let me speak briefly. She has enormous judicial experience, 14 years on the bench, 3,250 written opinions, presided over 271 trials. She's really handled some of the toughest questions that come before the court. So it's no surprise she received a unanimous, well-qualified rating from the ABA. What's more, the Ninth Circuit will benefit from her thoughtful approach. Second, in her tenure on the Northern District of California, Judge Koh's done precisely what we expect of federal judges, applied the law in an even-handed, impartial way. She's made clear to the committee that she will apply all binding precedents, quote, faithfully, fully, and fairly. I want to briefly address the claims made by some that she is biased against people of faith. Please look at the record. The committee received letters of support from Judge Koh's parish priest and from the St. Thomas More Society of Santa Clara County, which wrote, and I quote, "We believe Judge Koh's faith will serve her well as an impartial appellate judge." Of greater importance is the fact that the opinion allegedly displaying hostility, Tandon versus Newsome, is in reality grounded in law and precedent and was then the binding precedent in the Ninth Circuit. Judge Koh never targeted people of faith. She upheld content-neutral measures to protect all Californians. It's little surprise then that the Ninth Circuit affirmed the entirety of her opinion, and probably 2 judges who voted to affirm, notably, were Republican appointees. What's more, when it came before the Supreme Court, it was a 5-4 decision. The 4 Supreme Court justices which agreed with her opinion included Chief Justice Roberts. In short, claims of religious bias are not based on her life experience or her record. I will support her nomination and hope others will too. Jane Beckering, nominated to the U.S. District Court for the Western District of Michigan, experienced litigator, proven record of judicial independence, BA from University of Michigan, JD University of Wisconsin, Law School, and 17 years as a litigator in private practice. Experience in multi-state commercial litigation, plaintiffs' litigation, negligence, wrongful death, and product liability. Since her appointment to the Michigan Court of Appeals in 2007, she's shown that she understands the distinction between being a practitioner and a judge. She's presided over 4,070 cases, handled thousands of motions. Experienced, independent-minded, unanimously well-qualified rating from the ABA. Shalina Kumar, nominated to the Eastern District of Michigan, currently judge of the 6th Judicial Circuit in Oakland County, where she's been a judge since 2007. During her 14 years on the 2nd largest trial court in Michigan, she presided over 10,000 cases, more than 99 jury or bench trials, everything from civil to criminal to juvenile matters, effectively managed the court's navigation of the COVID-19 pandemic. Before taking the bench, she was in practice as a litigator and tried cases, 10 of them, to verdict, judgment, and final decision. Also rated unanimously well qualified by the ABA. Armando Bonilla, who's been nominated at the U.S. Court of Federal Claims, well qualified, Served as Justice Department for 24 years, from 1994 to 2018, working under presidents of both parties. Trial attorney in the Justice Department Civil Division, litigated over 100 cases for the Court of Claims, handled over 50 appeals before the Federal Circuit. Numerous roles in the Justice Department, previously nominated to be a judge on the Court of the Federal Claims in 2014, and the committee advanced his nomination by voice vote on 2 separate occasions. He would bring diversity to the bench as the first ever Latino judge on the Court of Federal Claims. Carolyn Lerner, nominated to also serve on the Court of Federal Claims, has ample experience as a neutral adjudicator, chief mediator for the D.C. Circuit, where she mediates approximately 10 cases every year. Earlier in her career, she was appointed by a D.C. District Court judge to serve as special inspector in a matter involving the D.C. Department of Corrections. When Ms. Lerner was nominated to lead the Office of Special Counsel in 2011, she received unanimous bipartisan support of the Senate, including the ranking member. Ms. Lerner has skills and experience needed to serve with distinction. Finally, we'll be voting on Jonathan Cantor's nomination to serve as the Assistant Attorney General for the Justice Department's Antitrust Division. Distinguished, experienced antitrust lawyer. Mr. Cantor began his career as an attorney for the FTC Bureau of Competition, spent 20 years in private practice as an antitrust lawyer, currently a partner in the Cantor Law Group. Over his career, he's been a leading expert and advocate on antitrust laws, especially in the digital economy. He has support across the political spectrum. In a letter to the committee, 9 former heads of the Antitrust Division, representing every presidential administration going back to Gerald Ford, strongly supported his nomination. I could give you some quotes to back that up, but trust me, I don't think I need to. With that, I'm going to turn to Ranking Member Grassley.
Our side would like to hold the arbitration bill and Connors, Cunham, and Karras to be held over. We have the False Claims Act up. It makes changes to the government's most powerful tool in fighting fraud so that it can protect the taxpayers.
I remember you're for that.
Yes, very much so. By the way, this isn't just a Grassley bill. This is a Grassley-Berman bill. When Berman was a member of the House of Representatives, he was our partner over there, so it was very bipartisan and very bicameral. So I give Congressman Berman a very liberal Democrat credit for working with a conservative Republican like me. So I want to highlight the good work of my co-sponsors on this committee, including the chairman and Senator Leahy and Senator Kennedy. Several of my colleagues including Senator Cornyn, have also been helpful in bringing this to a conclusion by helping us iron out some of the details of the manager's amendment, and I thank you all for doing that. We're also marking up the Driving for Opportunity Act, so we thank Coons and Wicker for their work on that bill. Very bipartisan, wide support, particularly from law enforcement and the criminal justice reform advocates. For most Americans, driving a car is essential. This is particularly true for rural Americans. The ability to drive a car is how folks get to work, attend church, buy food, go to medical appointments, and take kids to school. Millions of Americans have suspended or revoked driver's license solely because they haven't paid court fines, not because they're a public safety threat. This system is flawed. If the government wants people to pay fines, then the government shouldn't prevent them from getting to work. This catch-22 is tough on rural states and also those with criminal records trying to re-enter society by having gainful and lawful employment. The ability to drive is often critical for successful re-entry and very well could play a role in reducing recidivism. The bill encourages states to end counterproductive fine-based driver license suspensions. I'm a co-sponsor and support its advancement. I'd like to say a few words about yesterday's hearing. While I appreciate General Garland's appearing before the committee, unlike when he and his deputies outrageously ignored the Nassar hearing, it would be an understatement to say that I found his answers to very much less than satisfactory across the board. And I say that with special emphasis with respect to what he said about the infamous school board member. What's clear to the country is that this administration has weaponized the Justice Department and its component agencies against parents. The same department that engaged in widespread FISA abuse for years and almost got away with it. As I said yesterday, though these parents are trying to protect their children, they're worried about divisive and harmful curricula. They're speaking their minds about mask mandates. This is the very core of constitutionally protected free speech, and free speech is deadly to the tyranny of government and is the lifeblood of our constitutional republic. I'm going to vote for Judge Koh. I voted for Judge Koh out of committee 2016, consistent with that, and what I've told Senator Feinstein and Senator Padilla, I'm going to do so again today. But I want to note that I have reservations about her approach and reasoning in a number of cases. Judge Koh served as a prosecutor and has been a judge for a number of years. But she has also had a number of cases recently reversed by the Supreme Court. Just as an example, the Census Bureau to continue collecting data after the Commerce Secretary's deadline. The Supreme Court stayed that order with only one noted dissent. Her decision in Tandon about the ability to worship at home during the pandemic is concerning. And there is an important difference between Judge Koh and other nominees that we've recently seen in this administration. Judge Koh showed she actually willing to admit when she makes a mistake. She answered our questions about statements she made in the past. When asked whether she agreed with a comment that she had made in law school about how nominees should pretend to be objective, Judge Koh said, quote, "Not at all. I disagree with that 100%. End of quote. She also said, quote, "That is completely wrong. Our rule of law absolutely depends on impartiality, fairness, and I completely disagree with that statement." End of quote. That is a far cry from nominees who unwilling to recant saying that Justice Kavanaugh's conservatism means that people will die. I plan to closely look at her record before deciding how to vote on the floor. Thank you.
Thanks, Senator Grassley. Before we vote on Judge Koh, note that Senator Feinstein is asked to introduce a statement for the record without objection. Does anyone seek recognition to speak on Judge Koh? Senator Hawley.
Thank you very much, Mr. Chairman. I just want to say a word or two about Judge Koh. The Supreme Court has a docket of very limited size. It hears only a small handful of cases every year. In fact, it hears fewer and fewer every year, it seems, which is an interesting question of its own. But that means that in most cases, the buck stops with the courts of appeals, and that's why the nominees that we put on these appellate courts matter so much. The Supreme Court has reversed or otherwise blocked at least 3 of Judge Koh's decisions just in the last year. Now, I'm not aware of any other district court judge in the nation who has been reversed that often by the Supreme Court in such a short time. And what that means is she just isn't getting the law right. And that's a problem given the job that she's asking for a promotion for. I have serious concerns about giving someone a promotion when they're not doing their current job well. The most notable of these cases is Tandon versus Newsome. And that dealt with the fair application of COVID restrictions during the pandemic. She acknowledged that in this opinion that the state gave businesses an exemption that people of faith did not enjoy. Tattoo parlors, for instance, were fine, but worship was not. The Supreme Court of the United States pointed out that it is not permissible to allow hair salons, retail stores, personal care services, movie theaters, private suites at sporting events and concerts, and indoor restaurants to bring together more than 3 households at a time, and simultaneously to tell people of faith that they can't gather in groups of more than 3 households at a time. The Supreme Court particularly took issue with Judge Koh's assumptions in her opinion that people of faith were less likely to wear masks and socially distance and therefore could not be trusted to gather in their homes, while folks in commercial settings, all of these other places, retail stores, personal care services, movie theaters, private suites at sporting events, that those folks could be trusted to socially distance and to follow the rules. Here's what the Supreme Court said: the state cannot assume the worst when people go to worship, but assume the best when people go to work. And it reversed Judge Koh's opinion. I have serious reservations about all of the times that she was reversed by the Supreme Court, but I have to say, and I discussed this with her at length, her opinion in the Tandon case really is something to behold. The Supreme Court has said repeatedly for decades, you cannot treat secular entities more favorably than you treat people of faith. It has been a bedrock principle. Now, we have seen states and governors try to do this throughout the pandemic, try to favor retail businesses, try to favor money-making entities, try to favor folks that probably, frankly, bring in a lot of money or maybe contribute a lot of money to their political coffers, and disfavor people of faith. It is simply not permitted by the First Amendment of the United States. And to see Judge Koh not only go along with it, but bless it, and to assume, as she does in her opinion, for which she was explicitly rebuked by the Supreme Court, to assume that people of faith cannot be trusted, I think is very, very disappointing, to say the least. And again, I questioned her at some length about this. You know, I had the privilege to be a religious liberty litigator for most of my time as a practicing lawyer before I was Attorney General of the state of Missouri. In that position, in that role, I had the chance to defend many people of faith, of different faiths and minority faiths in this country. And what I saw repeatedly as a pattern is that folks who were in majority positions often disfavored those of a different faith because they didn't trust their intentions, they didn't trust their goodwill. I have to say that Judge Koh, assuming that people of a different faith wouldn't follow the guidelines, but people in commercial settings, businesses, other things approved by the state would, is deeply troubling. The Supreme Court was right to rebuke her for that. And for all of those reasons, I just can't support her nomination. Thank you, Mr. Chairman.
Thank you, Senator Hawley. As I noted in my opening statement, Judge Koh has issued more than 3,250 written opinions. You take exception to 3 recent reversals. Certainly there is a body of work there that helps define what she really believes. And of course, she is bound by the precedent as a district court judge of the circuit that she serves in. And that was, she told us repeatedly, was the basis for her decision in Tandon versus Newsome. That case then went to the Ninth Circuit, and the Ninth Circuit affirmed her opinion in that case. And it included 2 Republican appointees who sided with her as well. Then it was taken to the Supreme Court. You've used the word rebuke over and over again. It's your right to do that. The decision by the Supreme Court reversing her original trial court decision was a 5-4 decision. And Chief Justice Roberts sided with her and her position on the issue. I don't think that's as much a rebuke as a close call, as close as they come at the Supreme Court. She's made it clear from the start that she has no bias against people of faith, and she has the background support of those of her own religion, which evidence that. So I would say that you did raise that question, as others did repeatedly, and I think there is a solid response. Are there any others seeking recognition on this nomination? If not, on favorably reporting the nomination of Lucy Koh to be U.S. Circuit Judge for the Ninth Circuit, the clerk will call the roll.
Mr. Leahy.
Aye.
Mrs. Feinstein.
Aye by proxy.
Mr. Whitehouse.
Aye.
Ms. Klobuchar.
Aye by proxy.
Ms. Klobuchar.
Aye.
Mr. Coons. Aye. Mr. Blumenthal. Aye. Ms. Hirono. Mr. Booker.
Aye.
Mr. Padilla.
Aye.
Mr. Ossoff.
Aye.
Mr. Grassley.
Aye.
Mr. Graham.
Aye. By proxy.
Mr. Cornyn.
No.
Mr. Lee.
No.
Mr. Cruz.
No by proxy.
Mr. Sass.
No by proxy.
Mr. Hawley.
No.
Mr. Cotton.
No.
Mr. Kennedy.
No by proxy.
Mr. Tillis. No. Mrs. Blackburn.
Aye.
Chair Durbin, the votes are 13 yeas, 9 nays.
The nomination will be favorably reported to the floor. Does anyone seek recognition to speak on Jane Beckering, nominated to the Western District of Michigan? If not, on favorably reporting the nomination of Jane Beckering to be U.S. District Judge for the Western District of Michigan, the clerk will call the roll.
Mr. Leahy.
Aye.
Mrs. Feinstein.
Aye by proxy.
Mr. Whitehouse.
Aye.
Ms. Klobuchar. Mr. Coons.
Aye.
Mr. Blumenthal. Ms. Hirono. Mr. Booker. Mr. Padilla. Mr. Ossoff. Mr. Grassley.
No.
Mr. Graham.
Aye by proxy.
Mr. Corning.
No.
Mr. Lee.
No.
Mr. Cruz.
No by proxy.
Mr. Sass.
No by proxy.
Mr. Hawley.
No.
Mr. Cotton.
No.
Mr. Kennedy.
No by proxy.
Mr. Tillis.
Yes.
Mrs. Blackburn. Mr. Chair.
Aye.
Chair Durbin, the votes are 12 yeas, 9 nays, and 1 pass.
The nomination will be favorably reported to the floor. Does anyone seek recognition to speak on Shalina Kumar, nominated to the Eastern District of Michigan? If not, on favorably reporting that nomination, the clerk will call the roll.
Mr. Leahy.
Aye.
Mrs. Feinstein.
Aye by proxy.
Mr. Whitehouse. Ms. Klobuchar.
Aye.
Mr. Coons. Mr. Blumenthal. Ms. Hirono. Mr. Booker. Mr. Padilla. Mr. Ossoff. Mr. Grassley.
No.
Mr. Graham.
Aye by proxy.
Mr. Corning. Mr. Lee.
No.
Mr. Cruz.
No by proxy.
Mr. Sass.
No by proxy.
Mr. Hawley.
No.
Mr. Cotton.
No.
Mr. Kennedy.
No by proxy.
Mr. Tillis. Mrs. Blackburn. Mr. Chair.
Aye.
Chair Durbin, the votes are 12 yeas, 9 nays, and 1 pass.
The nomination will be favorably reported to the floor. Does anyone seek recognition to speak on Armando Bonilla, nominated to the Court of Federal Claims?
I thought we could have a voice, it says here we could have a voice vote.
I understand as well that we can take a voice vote on Mr. Bonilla's nomination. So in favor will be reporting that nomination. All those in favor say aye.
Aye.
Those opposed, no. In the opinion of the chair, the majority of members present having voted in the affirmative, the ayes have it, and
Could I be recorded as a no?
Senator
Mr. Chairman?
Hawley will be recorded as a no. Senator Blackburn will also be recorded as no. The nomination will be favorably reported to the floor. Does anyone seek recognition to speak on Carolyn Lerner, nominated to the Court of Federal Claims? I understand Senator Grassley informs me we can take a voice vote on that nomination. So on favorably reporting the nomination of Carolyn Lerner to be judge on the U.S. Court of Federal Claims, all those in favor say aye.
Aye.
Those opposed, no.
No.
The majority of members present having voted in the affirmative, the ayes have it. Senator Blackburn will be recorded as no, Senator Hawley as no, and Senator Lee as no. The nomination will be favorably reported to the floor. Does anyone seek recognition to speak on Jonathan Cantor, nominated to be Assistant Attorney General for the Antitrust Division?
Mr. Chairman.
Senator Cornyn.
Mr. Chairman, Jonathan Cantor has been nominated to be Assistant Attorney General for the Antitrust Division. I appreciate some of the comments that Mr. Cantor has made about his concerns with the tech industry. I share some of those concerns and have supported legislation in the past to curb big tech's influence in our daily lives. But the DOJ's Antitrust Division is much broader than just dealing with big tech. I'm troubled by Mr. Cantor's statements to the effect he intends to move away from the classic consumer welfare standard to a more activist approach to use antitrust tools as a hammer to achieve political or social ends. Mr. Cantor has been a frequent critic of the consumer welfare standard. This this test for determining anti-competitive activity was championed by jurists like Judge Robert Bork and Judge Easterbrook and has been applied by the courts for decades. Mr. Cantor subscribes to the modern antitrust enforcement regime or the new Brandeis movement, which potentially encourages the use of antitrust tools to pursue, quote, other competitive objectives, admittedly a very vague standard. This vague standard does give me pause, and the questions for the record that we submitted to him, his responses did not clarify how he would, quote, promote competition using, by pursuing competitive objectives. It just all seems like a mishmash. In his response to the questions for the record, for example, he left open the possibility of using antitrust laws to promote, quote, wage equality, quote, and to, quote, strengthen labor rights. Maybe worthy goals in terms of legislation, but not for an enforcer of existing law. In my view, these are issues that should be left to the Congress or to the marketplace. I share Mr. Cantor's goal of making sure that markets do work for the American people, but I don't support undercutting important antitrust legal principles in the service of short-term political goals. Thank you.
Thank you, Senator
Mr.
Cornyn.
Chairman.
I'm going to recognize Senator Klobuchar as chair of the Antitrust Subcommittee next, followed by Senator Whitehouse. And if there's a Republican seeking recognition, please let me know. Senator Klobuchar.
Appreciate my colleague's remarks. I lead with two words, Macon Delrahim. Macon Delrahim was the head of antitrust under Donald Trump, under Attorney General Barr, and he is supporting Mr. Cantor, and I'm sure he shares some of Senator Cornyn's views on Judge Bork and the like. But why he is supporting Mr. Cantor is that Mr. Cantor has the experience to do the job. And I thought during his hearing, having chaired his hearing and heard my colleagues ask questions, did an excellent job. 9 former assistant attorney generals, Republicans and Democrats, wrote a letter urging the Senate to act favorably and quickly as possible on his nomination. In addition to his expertise as a practicing attorney and his knowledge of the antitrust laws, he has a deep understanding of the major competition policy issues confronting enforcers in the U.S. around the world. We are at a critical moment for antitrust. And there has been such incredible bipartisan work going on in this committee. Senator Lee and I working together on Senator Lee's venue bill to making sure that our attorney generals of this country, from Texas to Minnesota, are able to keep their lawsuits in their own state. Senator Blackburn and Senator Blumenthal's work that is going on the app stores, in addition to the groundbreaking hearings that we've had in the Commerce Committee, of which they've chaired, the subcommittee, about what's going on with Facebook. And I just don't think that there may be differences on certain answers that Mr. Cantor said or things he said in his life. Overall, he is where this committee is in terms of how we've talked about this. Senator Grassley and I have worked together on our merger fee statute that went through this committee unanimously, just to allow the division, antitrust division of the Justice Department, as well as the FTC, to take on cases, yes, against Facebook and Google, that are groundbreaking cases. But what this gets down to is a runaway consolidation in our markets, cracking down on today's monopolies, regardless of what judges you like from the past. We unite on one thing, and that is that we believe in capitalism. We believe in allowing the markets to work, and the markets aren't working really well right now for some people. When you've got parents, one mom said to me yesterday that she felt like the faucet was on and the sink was overflowing, and she was just standing out there with a mop trying to protect her kids from the kind of crap that they're seeing on Facebook and Instagram and Snapchat and TikTok, and she can't keep up with learning all of the filters and what to do, and she keeps trying to mop it up as she's raising kids on her own. That's what we're talking about here. So we can disagree, and Senator Cornyn and I have done so much good work together. We can disagree on whatever Mr. Cantor said about one judge, but we know that this is a moment in our country's history where we once again, as past senators have done, past Republicans have done, going back to Senator Sherman, going back to what Teddy Roosevelt did when he came into the White House. Senator Hawley knows exactly what I'm talking about. This is a moment where we can unite and get behind a nominee, just as I got behind Macon Delrahim when Donald Trump nominated him, because I understood we had to move forward, even though he might not have been my first choice for antitrust. And lo and behold, I didn't agree with everything he did. I know Sheldon Whitehouse didn't agree with everything he did, but he did move forward with that Google lawsuit. He did make change and start us in the direction, and now that baton will be taken up by Jonathan Cantor, and we should, as a bipartisan committee, we should give him the opportunity to do that. Thank you, Chairman.
So Senator Whitehouse and Blumenthal have sought recognition, but Senator Hawley has as well, so we'll go back and forth. Senator Hawley's next.
Thank you, Mr. Chairman. I just want to add something to what Senator Klobuchar just said about the mother that she talked with, her testimony from, who said that it is an overwhelming job to try and stem the flow of what she sees online for her children. As the parent of the father of 3 young children, very young children myself, I understand that. And I just want to say it's a strange circumstance in our market system when so many parents and so many individuals feel that way, but can't find good alternatives online. Now, why is that? Why is it that we're not seeing competition that will produce alternative platforms to which these parents and others can go? Why isn't there competition around privacy? I think part of the answer is these companies are monopolies. We have a classic monopolistic system developing in the tech world where competition is artificially suppressed, and that's a huge problem. One of the reasons Facebook became Facebook and edged out MySpace is that early on, Facebook said they would protect privacy and MySpace wouldn't. They competed. Facebook won. But since that time, Facebook has set about buying up all of the competition, and now they're worse than MySpace ever was in terms of invading privacy, in terms of shoving all kinds of objectionable content at kids, in terms of taking power away from consumers, taking their private property, giving them no recourse. So my own view is the biggest problems we face in the tech sector really have to do with the hyper-concentration and the consolidation that we see in that sector. Now, I've got my own concerns about Mr. Cantor. I can't say that I agree with him on everything. In fact, we probably disagree on more than we agree on, but I do appreciate his understanding that the hyper-concentration and consolidation of the tech sector is a big problem, and I think he believes in antitrust. I think he wants to do something about it. So for those reasons, I'm going to vote yes on his nomination.
Thank you, Senator Hawley. Senator Whitehouse is next, followed by Senator Lee, then Senator Blumenthal.
Thank you. First, I want to make clear that I intend to support the nominee, but I want to flag while we're talking about the antitrust situation that we continue to have problems getting information out of the Department of Justice. And one of the things that I'm interested in trying to figure out is what the hell happened with the letter that Mr. Delrahim wrote to the 4 auto companies after the fossil fuel effort to blow up fuel efficiency standards failed. I think it's pretty clear that that letter was out of step with very basic doctrine of antitrust law. It did not have a basis in substantive law, and that it was inconsistent with internal procedures of the Antitrust Division in the Department of Justice for sending such a letter. So when you got the law wrong and you're cheating on the process, that's a pretty good sign that something has gone wrong. The backstory to this is that the auto industry came into the Trump White House and said, we'd like to revisit some of the fuel efficiency standards that we agreed to with President Obama. We've looked at them, and there's some smaller changes we'd like to make. And they cracked the door open, and when they cracked the door open, the fossil fuel industry blew the door down, came in, took over the negotiating position of the auto industry, not only tried to eliminate fuel efficiency standards at the federal level, but tried to eliminate the ability of states, the so-called California rule, to propagate their own fuel efficiency standards. And the auto industry realized that they had just been blown out of this. They were no longer being listened to. They were chumps in the game. So they went and they spoke to California. And 4 big auto companies cut a deal with California and announced that deal. President Trump was reportedly enraged by that announcement. Rats foiled again. And I can only imagine how enraged the fossil fuel industry forces behind that little scheme must have been. And it was in that context, suddenly, this legally unjustified and procedurally aberrant letter comes out of the DOJ Antitrust Division precisely to those 4 auto companies. Now, I'm told the Inspector General is looking into this, and I think it's important for the committee to give due scope to agency inspectors general while they're doing their work. But I don't want to be in a position in which we're being either slow-walked or denied information. I'm perfectly happy to cooperate so that we're not interfering with the Inspector General's investigation, but we're a separate branch of government. This committee has its own authority to look into things, and I'm getting really frustrated by the slow walking and the dribs and drabs of information that we're getting out of the Department of Justice. So I just wanted to make that point clear while we're talking about this antitrust position, and thank you, Chairman.
Thank you, Senator Whitehouse. Senator Lee stepped out. He'll be back. Okay, I'll recognize Senator Blumenthal.
Thanks, Mr. Chairman. I want to associate myself with remarks made by Senator Klobuchar, who has articulated very well the reasons that I and others on the committee will support Mr. Cantor. But I want to say about his enforcement philosophy, but that I believe he will use existing law. Thanks to Senator Klobuchar and Senator Lee, we are moving in a very bipartisan way toward improvements in our antitrust law that may enable more effective protection of competition in social media. We've seen some of the abuses in the subcommittee hearings that I have chaired on the Commerce Committee relating to Facebook, Snapchat, YouTube, and TikTok. But we also need to explore the power and the misuse of that power that they have acquired in the current market. The abuses are largely through the use of information that is driven through algorithms and enables them to target destructive and toxic content to children and others. It enables them to amplify emotional and provocative content that keeps users on the site and, in fact, drags children into dark places, heightening their anxieties and insecurity, anger, depression. That information, at the same time, is the source of a lot of their monopolistic power. The data they collect on those users, and the users themselves are the product, and their monopolistic control over that product, creating barriers to entry, is the source of a lot of their power. So there is a powerful intersection here in the collection of information from kids and other users who themselves are the product and provide the information that enables this power. We have seen tactics on the part of these companies, whether it's copy or kill relating to new products, the fees charged to apps, a series of potential abuses of power that are enforceable as antitrust violations under existing law. I'm counting on Mr. Cantor to be a powerful, aggressive, and vigorous advocate and enforcer of existing laws against the misuse of monopoly power by Facebook and other big tech companies. I think that it will provide a potential source of protection for consumers and competitors, because right now what we're seeing is a classic state of predatory conduct by monopolists, which creates barriers to entry, excludes competitors, and ultimately harms consumers by also stifling innovation and competition. So I will be supporting Mr. Cantor. I believe he'll be a vigorous enforcer and that he'll use existing law to protect the marketplace and consumers. Thank you.
Thank you, Senator Blumenthal. I understand from Senator Grassley that we can consider a voice vote on Mr. Cantor's nomination. So on favorably reporting the nomination of Jonathan Cantor to be Assistant Attorney General for Antitrust Division, all those in favor say aye. Aye. Those opposed, no.
No.
The opinion of the chair, the ayes have it.
I'd like to
Senator
be recorded as no.
Cornyn will be recorded officially as no. Any others? The majority of members present having voted in the affirmative, the ayes have it. The nomination will be favorably reported to the floor. I understand we can also proceed with an en bloc voice vote on 3 U.S. Attorney nominees receiving a vote today. I'd like to say at the outset that I've spoken personally to Senator Tillis and Senator Burr, and I don't know if you would like to comment on the process and your position on these 3 nominees.
Thank you, Mr. Chairman. Michael Easley, Sandra Harrison, and Dina King have been thoroughly vetted. We've met with all 3 of them. I've conducted a number of interviews. We've also worked with our colleagues on the House side and have the full support. We submitted only these 3 nominees to the administration. They were quickly vetted, and I would appreciate support.
Thank you. Now, there were 6 nominees in this package from the White House. They included the 3 from North Carolina and U.S. Attorney nominees for Hawaii, Rhode Island, and Vermont. There was a request by one of the members to hold over the 3 from Hawaii, Rhode Island, and Vermont. We are going forward. My decision was to go forward with the nominations from North Carolina today. So on favorably reporting the nominations of Michael Easley Jr., Sandra Hairston, and Dina King to be U.S. attorneys in North Carolina, all those in favor say aye. Those opposed, no. The majority of the members present having voted in the affirmative, the ayes have it. The nominations will be favorably reported to the floor. For the record, during the Trump administration, we believe there were 85 nominees for U.S. attorneys and 3 were held over. So this is not unprecedented that we're holding over attorney nominees for a week, but only 3 out of 85 during the Trump years had that situation. Now we are going to consider the legislation pending before us, the bills on today's agenda. The first is S-2428. Senator Grassley has spoken to this several times eloquently. Senator Leahy and myself, Senator Kennedy and Wicker support him. This bipartisan bill continues Senator Grassley's long tradition of working with Senator Leahy to strengthen the False Claim Act. He's even brought a textbook to the floor today. So let me defer to Senator Grassley. There's nothing I can say about this bill that will match his knowledge and fervor.
This has always been a bipartisan bill going way back to 1986. As I complimented Congressman Berman for helping me with this in the House of Representatives in my first term in the United States Senate. But Durbin, Leahy, and Kennedy working on it very closely this time, and all members of this committee further backs that up. Today, the False Claims Act is the government's most powerful anti-fraud tool, recovering more than $64 billion in taxpayers' money since the amendment passed in 1986. The Justice Department has even said that the False Claims Act is the #1 tool for fighting and deterring fraud against the government. Now, more than ever, the False Claims Act is necessary to combat cases of fraud, waste, and abuse in government funds. In 2020, the Justice Department opened a record number of False Claims Act cases and investigations due to sweeping number of COVID-19 related allegations. This is only beginning. Immediate action to strengthen the FCA provisions is absolutely essential to protecting the taxpayers' money. And this is an example of the Congress being a check on the judicial branch of government. And the sad part about this is, because I keep referring to the Escobar case, we're in a problem just because a dicta stated in the Escobar case, not because of anything that's very clear in the decision. And thank God not every court case since then has relied on the dicta. Some of them have gone contrary to that. But since the Supreme Court decision in Escobar, courts have grappled with how to evaluate the government's knowledge of alleged fraud when determining whether the defendant's misconduct was material to the government payment decision. So here we make very clear we don't have to rely on different courts interpreting it in a different way. These amendments would clarify misinterpretations created by the Escobar court by clarifying what should already be common sense. In other words, that common sense is just simply getting back to what we intended in 1986. The government's continued payment of a claim, despite knowledge of fraud, is only probative of materiality when no other reasons can be articulated by the government's continued payment. Now, I know some of my colleagues believe the government's decision to continue paying a claim should automatically be dispositive. They have bought into what is now the healthcare lobby's lies that not only doing so will increase healthcare costs, but let me say to you this: were healthcare costs highest prior to Escobar? Of course not. These are the same groups of people that hike drug prices on seniors while defrauding Medicare at every turn. Last year alone, healthcare fraud accounted for about $8 1/10 billion of false claims recovery. I think we get an average about $3 to $4 billion a year from this legislation. So it looks like healthcare costs might even take up more than half of the reason to keep this legislation strong. So we have a chart here that says two things: where healthcare fraud is, and also to show that this law has a disciplining effect on people that are inclined to fraud. Because when we first started this legislation in 1987, it was because we exposed $750 hammers and $600 toilet seats in the spare parts purchasing by the Defense Department. That made a very strong case to strengthen the key TAM provisions of this legislation. And you can see how defense spending, the blue line here, has leveled out. But it hasn't had the same disciplining effect upon health care, although I assume without the False Claims Act, you'd have even more fraud in both of these instances. So I hope you understand that it isn't only getting back fraud money, but what we save as a result of the disciplining effect on people that might be fraudsters, that won't be fraudsters because they might get caught at it and get it back. So let's see, where did I leave off here? Last year, so out of this $1 8/10 billion, most of that money was returned to the Medicare Trust Fund. So this not only strengthens, just protects the taxpayers, but it protects the Medicare program. I also want to point out that I spoke to healthcare systems in Iowa, and we're not aware of a single instance where this action would cause harm or be unfair. So I only say that because in my state, we don't have this problem of worrying about whether we have a strong False Claims Act. So I think it confirms, if you play by the rules and don't attempt to defraud the government, this bill will not impact you. Simply relying on the government's payment history without further context will inevitably lead to erroneous outcomes and increase in fraud. These changes are more important than ever. Over the last several months, the government has spent trillions of dollars towards relief programs and stimulus packages in response to the pandemic. Given the circumstances, then, it is highly unlikely that the government would discontinue payments for services under these relief programs. So for those of you that think that the government continue to pay something, even if they know about fraud, relieves the fraudsters of their of being condemned for that fraud, you can see why when we appropriate money to stimulate the economy, help people that are hurt as a result of the virus, we put these trillions of dollars out there and the government keeps paying them, well, they aren't going to cut off the payments. So if there's fraud, you get the fraud after the fraudulent act has been paid. So if you're saying that they can't be prosecuted under this legislation because they continue to make the payments, and that's what materiality is all about, you can understand that you're not going to have the discipline effect of this legislation. The proposed amendments that we put before you in this bill ensure that fraudsters will not get away with enriching themselves at the expense of the taxpayers. The amendments further, now on a second point, the amendments further clarify Congress's intent of a common sense definition of word hearing, quote unquote, the word hearing, and require that a hearing be provided before the government can dismiss the claim. Under this provision, the rational basis test is codified to prevent the government from dismissing a case over arbitration. Now, if you want to read about all the cases in the False Claims Act, you can read them right here in this book. So in regard to this hearing situation, we've had 4 different interpretations by 4 different circuit courts on what the meaning of a hearing is. Well, isn't it our responsibility to make clear what Congress means by the word hearing? So these provisions are intuitive and reiterate what already exists in our law or was intended to exist in our law. Due process requires the government to explain its reasons for a dismissal request. Ultimately, the federal judiciary maintains discretion over the time and resources allocated in each case. A judge cannot waste time on hearing a case they cannot act upon. The question before us today is, as we work to pass this legislation, it's this simple. Why should the taxpayers pay the price for bureaucrats who fail to expose fraud against the government? In other words, if you're raising questions about materiality and the government continues to make payments, and the fact that they know about fraud, they continue to make payments, that's some reason that you can't collect that fraud money. It just doesn't meet the common sense test. So if bureaucrats aren't doing their job, continue to pay the money, they know about fraud, you can understand that that just isn't the way we ought to be running the government programs. So I guess I'm happy to, from time to time, like Senator Leahy and I've had to do, I don't know how many times we've had to pass this type of legislation because some court just gets it wrong. And you've helped me with that. And it's been bipartisan ever since we got this legislation passed, because you aren't going to be caught under this legislation unless you are a fraud or fraudulently taking money. So what's wrong with that? I yield.
Mr. Chairman.
I'll recognize Senator Leahy. Let me first say that Senator Grassley and Leahy have prepared a manager's amendment, and without objection, that will be adopted. Now I recognize Senator Leahy.
Mr. Chairman, I just want to say I share my friend Senator Grassley's passion in this, but as a Vermonter and New Englander, I may be a little bit quieter in my statement of that. But we have worked closely together on this, and I strongly support it, and I applaud Senator Grassley for his work, and I applaud his cooperation with working with others on this.
Does any other senator seek recognition to speak or offer an amendment?
Mr. Chairman,
Senator Cotton.
I would like to call up my amendment ALB 21H14.
With the senator like to explain his amendment?
Yes, briefly. First, let me say that I support the False Claims Act, which has been used to root out fraud and wastes of taxpayer dollars. And I greatly admire Senator Grassley's decades of work on the False Claims Act and other measures to prevent government waste, fraud, and abuse. But it's also true that the False Claim Act can be abused and it can drive up costs in the healthcare system for patients. The False Claims Act was intended to address false claims that are intentional and material. If a doctor inadvertently checks the wrong box on a form or makes some other immaterial decision, I believe he should not face financial ruin for that mistake. Today, healthcare regulations are already too complicated. There's over 600 individual sets of regulations that hospitals and providers must comply with every day. I believe that Justice Thomas and the unanimous Supreme Court made the right decision in Escobar. The court said if the government knows a provider is not compliant with this or that regulation, but keeps paying, then it's, quote, strong evidence that the noncompliance was not material. I understand that the sponsors think that lower courts have been getting this wrong, and that may be the case in some decisions, but that's also why we have courts of appeals and while cases work their way through those courts until they can be finally resolved, perhaps once again at the Supreme Court. The bill today that we're voting on says the government's continued payment can never be dispositive towards the issue of materiality as long as the government can list any reason whatsoever that they still made the payment. I believe, and more importantly, I've heard from many doctors and hospital administrators and other providers in Arkansas who believe that there may be some cases where the government's continual payment should be dispositive. Not always, but should in some cases be dispositive in favor of the healthcare provider. So I would suggest that instead before we make such a change that potentially could increase healthcare costs, we develop a sounder factual basis. So my amendment would include the provision in this bill that requires the GAO report to study the question to give us a strong factual basis to avoid any unintended consequences. I ask for support for the amendment, and I ask for a roll call vote.
I'd like to speak.
Before recognizing Senator Grassley, it's my understanding this amendment does away with virtually every provision of the underlying bill, save Section 5 in the bill, which requires a GAO study. I will oppose the amendment and recognize Senator Grassley.
Yeah. Say, in regard to health care costs going up, this chart's pretty clear with the claims that have been recovered, that they'd be even higher if we hadn't recovered the fraud that's in it. And then I speak about the discipline that's in this legislation, that people might feel that some whistleblower knows what's going on and they're going to report it, and then it'd be even higher. So I think, and then also when it comes to a study, I don't know what more study you need than all's in this book about what's good or bad about the False Claims Act. And so I think, just for history, yesterday was the 35th anniversary of this legislation. As the chairman said, this strips everything in the manager's amendment except the GAO report. Now, for the senator's benefit, I included the GAO report in my bill and the manager's amendment to continue tracking the statistics that we have gathered over 35 years. And for the most part, General Accounting Office has been involved in a lot of those studies. So we don't need a study for a law that works. I mean, are you going to find any fault with bringing in $64 billion of taxpayers' money? I have great respect for Senator Cotton. My bill, I guess I'd have to say I don't understand your position based upon what we know about it and the $64 billion that's come back in. My bill attempts to fix just nothing but circuit splits. As Leahy and I have tried to point out, for decades, we've had to go back and fix court decisions that have misinterpreted and at the same time weakened the legislation. And a lot of this is based upon dicta, not what was in the main decision that we're trying to fix. So this bill's about tuning up a very well-oiled machine. At its heart, the FCA
is about making sure that taxpayers get what they pay for, whether it's bullets in the case of the Defense Department, body armor for policemen or our troops, health care for our seniors. When lives are on the line, they don't need to be second-guessed about the quality or the cost of their equipment. And the Department of Defense can't afford to stop or suspend payments for vital equipment, even when it is suspected of fraud. So doggone it, it's just this simple. The fact that the government continues to pay out, even if they know there's fraud, that's evidence that you haven't done anything wrong. It just is ridiculous. Our military shouldn't have to choose between protected men and women in uniform or stopping payments so the Department of Justice lawyers can successfully bring a claim under this bill. I want to give you an example from the Afghan war. There are also instances of back actors frustrate the government's case by helping perpetrate the fraud. I've spoken 3 times on the floor of the United States Senate about our government spending $535 million to buy 20 cargo ships or cargo aircraft in Italy, I believe it was, and then they were never used. They had to be rehabbed. They were never rehabbed. They were sold for, compare the $539 million to the $40,000 we got for scrap out of that. Now that's obviously not right and shouldn't go forward.
Anyone else seek recognition?
If I could just state
Senator Leahy.
very, very quickly, Senator Grassley and I know that you, Mr. Chairman, and Senator Kennedy, we've all worked very, very hard to get all input from all the stakeholders, private sector voices, Justice Department, everybody else. We've had this delicate balance. As I said before, I've enjoyed working for years on this with Senator Grassley. I know he has worked very hard to make sure everybody is listened to, but we end up with the same thing. We want to protect taxpayers, and that's what this bill does. I would oppose the amendment. I'll support the original bill.
Senator Cotton, I see no one else seeking recognition. Do you want to close the debate?
I'll say that I have the greatest respect for Senator Grassley's defense of taxpayers. I'm pleased to have offered the amendment on behalf of the Arkansas doctors and providers from which I've heard. I suspect I'll have no more good luck in this legislative debate than I do in push-up contest with Senator Grassley. So I'm ready to move to the vote.
Senator, do you want a voice vote or roll call?
Voice vote would be fine.
All right, the question is on the Cotton Amendment. All those in favor of the amendment say aye.
Aye.
Let me rephrase the question. Pending is the Cotton Amendment. All those in favor of the Cotton Amendment
No.
say aye.
After beating me in so many push-up contests, Senator Grassley was taking pity on me there.
And depending on the chair, the noes have it, and we so reported. Are there any further amendments to be considered?
Mr. Chair.
Who's seeking? Senator Tillis.
Thank you, Mr. Chair. I just want to briefly make a few comments about the False Claims Amendments Act. I actually filed 8 amendments. Not going to ask for a vote on them, but I do want to walk through some of my concerns with the legislation. And I do that with some trepidation, knowing that Senator Grassley started working on this bill when I was 27 years old, and Walk Like Egyptian was at the top of the billboard charts. You've got a lot of history in here and a lot of passion around it. Look, I support whistleblowers, and I think every senator here wants to make sure we have robust laws in place to prevent the $500 toilet seats and the $700 hammers. But I think this bill goes too far. It'll result in a massive payout for trial lawyers and disgruntled employees who want to harass and intimidate small businesses across the country. In its current form, the bill will encourage frivolous litigation, unfairly disadvantage defendants, and increase cost to consumers. The Supreme Court unanimously recognized that the False Claims Act should not be used to punish garden variety breaches of contract or regulatory violations, and this bill would exacerbate and accelerate abuse legislation. It would place a higher burden on defendants to disprove their liability than it does on plaintiffs to establish their liability. This contradicts the basic principles of fairness and would establish a dangerous precedent that plaintiffs' lawyers may try to export in other contexts. It would penalize companies for obtaining evidence they need from the government by making them pay the government's cost for producing the information. At the same time, it does not contain a reciprocal provision allowing companies to be reimbursed for their costs if they respond to excessive requests for information. I don't see any fairness in that. It would limit the Department of Justice's ability to dismiss meritless cases, making it more difficult for the government to control cases. Suggests this bill is not about protecting against fraud and abuse, but rather about advantaging plaintiffs' attorneys. The bill's changes to current law apply retroactively, including cases that have been litigated for years. I believe the bill is a massive giveaway to plaintiffs' bar and will hurt small businesses and consumers in its current form. That's why I submitted the 8 potential amendments, which, if they were adopted, would go a long way towards improving the bill. My amendments would reward robust business compliance programs that lead to voluntary disclosure by reducing damages. My amendments would prevent small businesses from being sued for violations based on generic catch-all language and forms that have nothing to do with the payment at issue. And my amendments would ensure that the cost-shifting discovery provisions applies to all parties and to all instances where there may be excessive requests for discovery, and would require the government to disclose exculpatory evidence to the defendant. These are common-sense measures that would improve the bill, and I'm disappointed that these suggestions, along with others, were rejected in our committee staff discussions. I want to support whistleblowers, and I want to make sure we have tools people need to make sure taxpayers are not defrauded. But I'm concerned this bill will encourage enterprising plaintiffs' lawyers to go on fishing expeditions against small businesses. I think that's wrong, and that's why I oppose the bill in its current form, and I plan to vote against it today. I hope that I can work with the ranking member and others to get this to a place where I can support it as it moves forward. Thank you.
Can I respond?
Senator Grassley.
You're relying too much on the original bill, and you haven't taken into consideration, I wouldn't say we've responded to all 8 of what your amendments would do, but we did respond to the retroactivity. There is none. We did deal with recovery costs. There's nothing in there on that now because of the manager's amendment, and then no burden shifting.
Well, it's moving in the right direction. Hopefully we can get more progress as it moves forward.
So the senator from North Carolina indicates he will not be offering an amendment at this time.
No, I will not.
Are there any further debate or amendments to be offered? If not, we will vote on final passage. The clerk will call the roll on S 2428.
Mr. Leahy.
Aye.
Mrs. Feinstein.
Aye by proxy.
Mr. Whitehouse.
Aye. I did that for you, Senator Grassley. Aye.
Okay. Well, I just want to make sure, because sometimes people on my side, Senator Kennedy, did you want to speak?
I did.
Okay. Thank you for getting here before we vote. Yeah. Well, I don't.
I can do it in 30 seconds.
Yeah, please do it.
Well, we'll ask unanimous consent for the committee for Senator Kennedy to make a 30-second statement. Any objection? No objection.
Mr. Chairman,
Please.
Unless you folks screwed this bill up before I got here, I think it's a good bill, and I think we ought to pass it.
Clerk will resume the roll call.
Mr. Coons.
Aye.
Mr. Blumenthal.
Aye.
Mr. Rono. Mr. Booker.
Aye.
Mr. Padilla.
Aye.
Mr. Ossoff. Mr. Grassley.
Aye.
Mr. Graham. Mr. Corning. Mr. Lee.
No by proxy.
Mr. Cruz.
No by proxy.
Mr. Sass.
No by proxy.
Mr. Hawley. Mr. Cotton.
No by proxy.
Mr. Kennedy. Aye. Mr. Tillis. No. Mrs. Blackburn.
No by proxy.
Mr. Chair.
Aye.
Chair Durbin, the votes are 15 yeas, 7 nays.
The bill will be favorably reported to the floor. The other pending bill before the committee is S 998, the Driving for Opportunity Act by Senator Coons, and I'll turn it over to him to describe his bill.
Thank you, Mr. Chairman. Did you want to just proceed to the vote, and then I have longer comments? I'm happy to make at that point.
We have a manager's amendment, and then we can go by voice.
Well, without it, there is a manager's amendment pending. Is there any discussion of the manager's amendment? If not, it'd be offered by Senator Coons and adopted. And now, on favorably reporting the bill, S 998 is amended. All those in favor say aye.
Aye.
Those opposed, no. The majority of members present having voted in the affirmative, the ayes have it. The bill will be favorably reported to the floor, and Senator Coons.
Mr. Chairman, there's a member.
I'm
wants
sorry.
to-
Senator Hawley will be recorded as no.
I've got also Cotton, Kennedy, Blackburn, want to be recorded as voting no.
As well as Senator Cotton, Kennedy, and Blackburn will be recorded as no. But the chair notes that a majority still having favored for the passage of the bill. It will so be reported to the floor. Senator Coons, would you like to make a statement?
Thank you, Chairman Durbin, Ranking Member Grassley, both for allowing a markup of this bill today and for your co-sponsorship of this bill. Millions of Americans have their driver's licenses suspended today across our country, in large part just because they're poor. These debt-based license suspensions simply make no sense. When someone is poor or has just been released from prison, we take away their very ability to get to work, which then makes it harder for them to pay fines and fees that have led to that driver's license suspension. They're forced to drive anyway, to risk rearrest and new fines, trapping them in a vicious cycle. And these impacts disproportionately fall on black and brown communities in modern-day debtors' prisons. Studies show these license suspensions, in fact, don't help with collections, but consume significant law enforcement resources. Driving on a suspended license is something that is a common challenge across our country, these laws then take away from law enforcement's ability to address public safety, and the consequences clog our courts and our jails. They also put men and women in uniform at risk in traffic stops that they are undertaking simply to be debt collectors. In recent years, fortunately, many states have recognized these policies should change and have made reforms. I am leading this bill with my colleague, Senator Wicker of Mississippi, to provide targeted and voluntary grants to states that choose to end these suspensions, providing modest one-time help to defray the associated administrative costs. It's co-sponsored by members of this committee, Senators Durbin, Grassley, Whitehouse, Tillis, Blumenthal, Booker, and many others. The bills are in support from groups across a wide range, from Americans for Tax Reform and Americans for Prosperity, to law enforcement groups like the FOP and the National District Attorneys Association, to business groups like the Chamber of Commerce, and civil rights groups like the Fines and Fees Justice Center and the ACLU. Let me close with two quick quotes, if I might, from Grover Norquist of Americans for Tax Reform. Denying a person a driver's license because they owe money creates a modern version of the debtor's prison. You can't leave your home until you pay your debts, but you cannot pay your debt if you cannot go to work. This is simply wrong. And from the American Association of State Highway and Transportation Officials, suspending licenses limits people's access to work, groceries, education, and health care, but doesn't increase safety. And state departments of transportation believe our focus should be on safety. Thank you, Mr. Chairman, for the opportunity to advance this bill, and I look forward to working with you to get it through the Senate and to the President's desk.
I want to thank you for introducing it. I visited the Cook County Jail with the Sheriff Tom Dart, and we talked about the reality of this situation. What happens, of course, is people in desperation drive without proper license, and then they're pulled over, and then there's an outstanding warrant for their arrest. while that happens, and that just leads to a tumbling succession of misfortunes that started with a very simple debt that went unpaid. So I'm glad you're doing this. I think it's interesting to put Grover Norquist and ACLU together, and you did it. Congratulations. Anything further? Senator Kennedy?
Yes, Mr. Chairman, and I'm sure Senator Coons has thought about this, but it would seem to me you can't repay a fine if you can't work. And a lot of people can't work if they don't have a car. It would seem to me that we could get together and work on some kind of legislation to set up a mechanism, to set up a payment plan, perhaps even give somebody the authority if a fine is absurdly high, particularly with interest, so we could kind of meet in the middle on this. And I'd be glad to work with you, Senator Coons, if you would like. It just seems to me we've got a lot of smart people in this room. We ought to be able to figure that out.
Now that you have arrived, we certainly do. And thank you, Senator Kennedy. Anyone else seek recognition? Senator
Mr. Chairman,
Ossoff.
I thank Senator Coons for his leadership with this legislation and ask unanimous consent to be added as a co-sponsor.
Without objection.